Welcome back to another edition of Institutions of National Government, Unit 4, Video 20, Supreme Court in Action. Alright, so it is a 36-week session. They meet from October until June, and then they enjoy their nice summers off. But that is a session of the Supreme Court. Each side of a case will present briefs to the Supreme Court. Briefs are simply written arguments for a case. So each side will present basically their papers, their report, in which they argue their side. This is where the Supreme Court gets the vast majority of their information, comes in the form of briefs. There isn't a whole lot of time that they spend actually listening to each side speak, so this is where, again, this is the most important part of the case. If you're presenting it, it's your brief, typically. A specific type of brief that you absolutely positively want to be very familiar with, so you would highlight this for sure, amicus curiae briefs. Amicus curiae briefs. Literally, that's Latin for friend of the court. So you need to know that, but then more importantly than knowing it means friend of the court is, well, what exactly are they and who submits them? It is when somebody who is interested in the case, but not directly involved in the case, submits a brief. So you have the original two sides directly involved in the case, they submit their briefs. Then other groups, oftentimes interest groups, they will submit amicus curiae briefs because they believe that this case is important to them. So, for instance, if there was a gun rights case where somebody, one individual person sued because they felt like their Second Amendment rights were being violated, they would be involved in the case directly, so they would submit a brief. But then the NRA and other interest groups would probably also submit briefs because they are interested in the outcome of that case. So amicus curiae briefs are most commonly submitted by two people, or two groups I should say, interest groups and the U.S. federal government. The Solicitor General, they are the third-ranking person in the Justice Department. Why we care about that person is that they personally approve every case the U.S. government presents to the Supreme Court. So it is their job, that is our current Solicitor General, it is their job to actually go up and speak in front of the Supreme Court, and you can see the sketch where he is speaking to the Supreme Court, arguing the United States side of the case. If he doesn't speak personally, he at the very least approves the case. So that is his job. He is basically representing the United States federal government to the Supreme Court. When it does come time for oral arguments, each side gets 30 minutes. So they go up in front of the Supreme Court, they stand in front of like a podium or a lectern, a green light turns on, that means that their time has started and they begin speaking. They give their speech, but sometimes as soon as they start talking, Supreme Court justices, they can interject and interrupt at any time that they want and start asking questions, cross-examining them. This is basically, it's our best opportunity to see what the Supreme Court justices are thinking. We can kind of tell by their questions sometimes how they might feel on a particular issue. So they'll ask questions, either helpful questions to make their side stronger, or they could ask them tough questions to make their side look bad. Either way. So again, you notice that there's sketches for both of these. That's because there's no cameras allowed in the Supreme Court. The Supreme Court is very private. But that is the basic idea of oral arguments. Now, after the case has been heard, so the Supreme Court justices, they have read the written briefs, they have heard the oral arguments, it's time for them to make a decision. A simple majority wins, so we have 9 Supreme Court justices, so a majority is 5. If it's a tie, so the only way it would be a tie, obviously, is if one of the justices chooses not to hear a case, which happens sometimes because maybe they have been involved in the case in some way, so it wouldn't be fair of them to decide it. If it's a tie, then the lower court decision stands. That is very rare, though. So it takes 5 justices to win a case. Alright, so there's a few different types of opinions. First is the opinion of the court. That is the majority decision. It is the winning side. So the official opinion of the court is whichever one has at least 5 votes. So it's the winner. There are also something called a concurring opinion. This is when justices agree with the majority, so they're on the winning side, agree with the majority opinion, but for different reasons. So they concur, but they have different reasons. So for instance, they say, yes, that side is the winner, but for a different constitutional reason than what the majority said. So they want to write their own opinion, so it's a concurring opinion. There's also a dissenting opinion. That's the opinion of the losing side, so the side with 4 or less justices on it. They can also write their opinions telling why the other side is wrong and why they're right. Now, of course, this has no legal, it doesn't enforce their decision at all. It is merely their opinion, but it's important that they are able to tell why they believe that their side is right. So that's the dissenting opinion. And the last kind, this is the least important probably, this is the per curiam opinion. It is a brief, unsigned opinion. These happen very, very rarely, rather, because usually the opinions, they're like small books, anywhere 40, 50, 60, 80 pages long, of the Supreme Court telling you exactly why they ruled the way that they ruled. The best example of a per curiam opinion is Bush versus Gore in 2000, when it came to settling the election of 2000. The Supreme Court is the one who really decided that Bush won that election, and because time was running out, it was literally 6 weeks after the election had taken place, so they, rather than write a huge long report, they put a per curiam opinion out, which basically just said, all right, Bush wins, he gets to be president. It was less than 1 page long.